Hi, this is Tim Santoni and welcome to Risk Mitigation TV. On this show, we want to help you mitigate risk in your business and protect you from those in your inner circle. As part of my efforts on this show is to provide information around investigations and background screening to help you mitigate risk. If you do business in the state of California, there's a very challenging climate for employers. In 2018, there was 84 new laws enacted by our legislators that impact employers, and several of them are very confusing and very complicated. So recently, I got to attend a legal update where 4 of the most preeminent employment law lawyers on the defense side here in Orange County got together and spoke about various topics. We had 4 people on our panel. Jehan Jayakumar with Carlson Jayakumar. He was talking about the legalization of marijuana in California and how it impacts employers and their ability to screen and create policies around use and of marijuana in the workplace. We also had DiSante of Crothers, DiSante and Frudenberger. She talked about the new law that limits employers' ability to ask about wage history and how that impacts their ability to recruit, retain, and attract top talent. We also had Brian Selvan, who's an employment and labor attorney. He was talking about arbitration agreements and the impacts of arbitration agreements to avoid class action suits depending on the size of your business and the costs involved. And lastly, we had Shawn Larson of Larson, Willis & Woodard, and he talked about AB 1008, which is affectionately referred to as ban the box, and how that impacts employers from application to background screening to adverse action and screening out those people that could create risk in the workplace. Here are some highlights from the panel.
As everyone knows, of course, California legalized marijuana effective this past January 1. So a lot of clients are asking, well, how does that affect my company and my policies? Interestingly, the state actually helped employers here in that statute and said, look, just because we're legalizing marijuana, it doesn't mean that it's going to be legal in the workplace. And in fact, the law actually allows employers to still maintain those same policies that we had last year, namely those policies that prohibit the use of marijuana in the workplace. What's interesting is, do we want to do that? What we're seeing across the country, mainly in states that have legalized marijuana, is that clients are getting away from drug testing altogether. Big companies like, I believe it was CarMax, is one big one that has now limited drug testing in the workplace. And the reason for that really is that with our tight labor market, companies don't want to lose out on candidates or lose current employees who may choose to smoke a little Mary Jane, in their
candidates for a position is that you cannot ask them questions about their salary history. So it used to be very standard on job applications or in the interview process to ask someone, where they work, what the position was, or what they got paid at their previous jobs, and employers often would factor that into determining what the amount of the offer that they were going to pay. Now it is unlawful in California to ask an applicant what they made at any of their prior jobs. And the thinking and the rationale behind the statute is that unquestionably there has been a disparity in pay that affects women and minorities as opposed to white males. And there is a wage gap. And the idea is if someone was paid a lesser amount than they should have been for discrimination reasons, you should not take that into account in what you're going to pay them in their next job, because that just perpetuates whatever wage disparity existed. Instead, what you should do is evaluate the position for what you think it's worth to you as an employer, and that's what you offer. And I don't think it's really hit yet, but I think it is going to. It's inevitable, in part because the pendulum has totally swung. I think the pendulum used to be, if you made a claim, it was assumed it was bogus unless there was actually a witness or documentary evidence, and if it couldn't be corroborated, it wasn't enough that it was just one person, typically a woman, accusing another person, typically a male, of some sort of harassment. And now it seems like the pendulum is totally in the opposite direction, where all it takes is an accusation and there's something wrong if you don't immediately believe it and fire the person, almost even before you do an investigation.
The current status is that those are in California and in the Ninth Circuit, those are not lawful. The reason is that the NLRB, the National Labor Relations Board, they actually stepped in. It was a little bit out of left field. They stepped in and said, we think those prevent employees from acting acting collectively. which they have a right to do. It's a concerted activity that's protected under the National Labor Relations Act. One thing I have been advising clients, and I think my colleagues have, perhaps have as well, is that one way of doing it is making it an optional waiver. So in other words, if you mandate that the arbitration agreement says you may not act in a concerted activity, or you may not act in a class representative manner, then that is something that, again, that's what the issue is here. But if you have a paragraph and a checkbox, and the checkbox says, if you initial here or if you check off here, then you agree that you will not, and this is optional and you don't have to do it, then that, I think, under the logic, should still be enforceable. Right? And so arbitrators, if you're using JAMS or AAA, arbitrators are charging $600, $700, $800 an hour. You
That's
look
not
at
easily $10,000 a day.
Yeah,
They can't do it.
absolutely.
Their pre-work before the arbitration and the arbitration itself.
We used to two-week arbitration
Still
summer.
less risky, but it seems like some of these newer laws are kind of reaching back to try to get at that. So this is ban the box, which is essentially a nationwide movement. California is kind of catching up. It's one of the few places we're catching up. And the idea behind ban the box is to take off from your employment applications the box that an applicant would check about whether they have a criminal history. And I think the idea behind that is if you've got somebody who's got a criminal conviction in their past, if that's checked on every single application for the rest of their life, they're never going to be able to get another job, never going to be able to move past that. Asking about it. Let's say you give somebody a conditional employment offer. After that, you are allowed to inquire about criminal conviction history. But then you sort of start a long process if the answer is yes. If the answer is yes, and hopefully the prosecutor gives the answer is no and you're done, right? If the answer is yes, then you've got to go through a notice process, essentially where you've got to consider not only the conviction, but you've got to consider a number of factors. I think they are the nature and the gravity of the offense, how long ago the offense was, and the nature of the job. Essentially, you can't just hear yes and say no job for you.
I thank you for hanging in there with us. We went a little bit over, but I want to have your help with giving a round of applause for our
I hope that some of the information you found in this video is useful in your business. And the reason I bring it up is because the employment laws here in California are very, very complicated. I encourage you to connect with an HR consultant or employment lawyer before you implement or make any decisions that impact your business. And feel free to reach out to any one of these experts on the panel, as they are very, very much experts in their field and can provide you with a great amount of resources to protect yourself and mitigate risk in your business. Thanks so much for tuning into the show. If you like what you see, please give us a thumbs up. I look forward to connecting with you in the comments. Thank you.